Hi, my name is Rob Dickson, and I'm an attorney here at Dickson Frohlich. The purpose of this video today is to discuss what a complaint is, which of course is the first step in litigation, or the first step in a lawsuit. The document itself is structured in a very straightforward fashion, starting with what is called the caption. The caption is basically the bureaucratic section of the complaint used to organize all the important identifying elements of the lawsuit in one place at the beginning. It includes the name of the court, the name of the parties, which are of course they're plaintiffs and defendants, and it includes a cause number. Now, this cause number is important because it is the court-assigned numerical identifier of the lawsuit that will go with it throughout its entire lifespan. Think of it as a sort of social security number for the case. You'll see this cause number on basically all documents that are created in sort of the pleading form, whether that be, the complaint to begin with, or the answer. You'll also see them in motions, brought by the parties, depending on the circumstances. And you'll see them even in the discovery that is exchanged between the parties. After the caption, the complaint then identifies the parties to the lawsuit and the court where the action is going to be fought. These comprise the two main jurisdictional elements of a lawsuit. And this is important because for a court to have jurisdiction over a matter, it must have both personal jurisdiction over the parties that are contending, but also subject matter jurisdiction over the type of law itself. Personal jurisdiction is obtained when the responding party, the defendant, receives proper notice of the complaint. This is done through personal service, where typically a process server will personally deliver the summons and the complaint on the prospective defendant. Subject matter jurisdiction is different. It deals with the court's authority itself and what type of law it is allowed to hear. For example, a federal bankruptcy court is not the appropriate court to hear a divorce case. A good way to think of jurisdiction is to think of it as analogous to organizing a sporting event. Not only must you have the proper players or teams, but you also have to have the right venue for the sporting event or the contest. If either of those two things are off, then you can't play the game. It's the same thing with initiating court action. The facts section is where the plaintiff gets to tell his story of why he has come to invoke the power of the court for help. Now, this isn't just any old story, nor is it necessarily meant to be a perfect retelling of the facts, but rather the plaintiff must include in this section the core events which, when read together, describe the circumstances that give rise to a violation of his legal rights. Now, it's important to note that Washington is what is called the notice pleading state. Now, what the heck is that? Well, what that means is that the plaintiff need only provide sufficient description of the events at issue to give reasonable notice to the opposing party about what is being disputed. The plaintiff is not expected to submit some novel-length description of the facts, nor is he even required to include exhibits, although some plaintiffs actually do. Rather, the plaintiff is really there in this section to describe with clear and straightforward terms the narrative, or again, the story of the case. After the facts section in the lawsuit comes the causes of action. Now, what is a cause of action? In essence, the cause of action is what the plaintiff is alleging was done wrong. It is the rule that was broken or the right that was violated. For instance, suppose the issue before the court was whether or not the parties obeyed a written agreement that they had between each other. The cause of action may be breach of contract, that the defendant didn't uphold his obligations under the written agreement. Suppose in another circumstance you had a lawsuit about a car accident where the defendant was driving a car and struck the plaintiff's car and caused injury or caused harm. That cause of action in that circumstance may be negligence, because the allegation would be that perhaps the defendant was acting negligently when he was driving his vehicle. It is important to note that sometimes you'll see in complaints a bunch of causes of action, even ones that sort of feel iffy. This is because if those causes of action aren't pled early in the process, the plaintiff may be barred from bringing them later. In other words, you can always get rid of issues or get rid of causes of action later on in the process, but as it goes along, the dispute sort of becomes crystallized into what the parties are fighting over. And so it's always important for plaintiffs to make sure they include as much as they reasonably can at the beginning in terms of the causes of action. The last section of the complaint is what is called the prayer for relief. Now, what is a prayer for relief? It's basically the section of the complaint where the plaintiff gets to ask the court for relief, or I guess stuff, right? So in the instance, as we discussed before, where perhaps there is a breach of a contract, maybe the plaintiff wants, monetary damages. That's something he would ask for. Let's say perhaps the complaint, also included a claim for negligence, like this sample one does. Well, there'd be an award for damages based on that negligence, and then almost always you see requests for attorney's fees, reimbursement of attorney's fees, because those can be significant. The prayer for relief is where the plaintiff gets to ask for those things. Thanks for taking a moment to watch our video about complaints. My name's Rob Dickson, and I'm an attorney here at Dickson Frohlich. And of course, if you have any questions, you can always call us at 206-621-1110. Thanks.